Thanks, everybody, and thanks, everyone, for making it here today. Really appreciate our panelists in particular braving the various challenges and hurdles that were imposed by Amtrak weather and other sort of exigencies in making it here, and appreciate Jerry's really valiant efforts to make it and being here on phone. This is something that I have wanted to do for a while. I think it's an incredibly important issue. Keeps me up at nights just wondering what's going to happen in the courts and in the regulatory arena on resolving the sort of the internal inconsistencies in preemption doctrine, and just nobody better than the panel that we have here today to discuss it. And we're totally going to save the world and figure it out this afternoon, and you guys are here to see it. I'm just going to introduce our moderator, David Cott, because I really appreciate his opening McCarter and English beautiful offices to host the event here today, and for David being willing to moderate this panel. As Marcus said earlier, David has been involved with our organization, New Jersey Civil Justice, since its inception. How many years ago, Marcus? Nearly 8 years ago. David Cott is a partner here at McCarter and English, and his work with New Jersey Civil Justice and other business groups in New Jersey is really legendary. He's a trial lawyer, and he really just devotes his intellect and energies to the sort of the greater cause of just the good of the law in New Jersey, and we rely on his insight and assistance all the time. He is an invaluable resource to the business community in New Jersey, and I'm going to turn this over to David. Thank you.
Thank you, Alita. Our first speaker is Paul Clement. Paul went to law school at the Cambridge County College of Law in Massachusetts, where he served as an editor of the Law Review. He was the 43rd Solicitor General of the United States. He clerked for Justice Scalia. And I think, but he can correct me, there is no current private lawyer who has argued as many times before the United States Supreme Court as Paul Clement.
Thank you very much. I think I'll just do it down here, if that's all right. In keeping with the spirit of it being a panel, I'll just stay sitting. So thank you all for being here and braving the elements, and thank you for that introduction and for this opportunity. I know this has been a long time in the planning stages, so I appreciate the perseverance that got us here today. So I'm going to kick us off by just giving a little bit of an overview about preemption law and generally, and the way that it's sort of come up in the medical device, branded and generic pharmaceutical context in particular. And then I think I'm going to kick it off to some of my co-panelists and look forward to a discussion to follow. So just in the broadest terms, I'm sure most of you are quite familiar with principles of preemption, but just to set the stage, preemption is an interesting sort of rubric, because what it really captures is a constitutional concept and a statutory concept. The constitutional concept, of course, is the Supremacy Clause. And under the Supremacy Clause, when there is a direct conflict between a federal regulatory provision or statutory provision and state law, then there's no question what breaks the tie. The Supremacy Clause does, and the feds get to win every time. So the questions under the Supremacy Clause then ultimately turn on, how much tension does there have to be between the federal law and the state law? What kind of federal law are we talking about? Is it a statute? Is it a regulation? Is it sufficiently clear both in what it does and its intent to preempt state law? And then there are also questions that arise about what kind of state law counts. For a long time, there were at least certainly some justices, in the occasional opinion, that really stood for the proposition that state tort law kind of didn't count or wasn't readily preempted by federal law. And the kind of classic preemption case is the federal government, passes a statute that says thou shalt do X. A state passes a statute that says thou shalt not do X or thou shalt do Y, which is, of course, not X. But the whole idea of extending preemption analysis to preempt state tort laws is something that it took a while for the Supreme Court to be comfortable with. But I think it's fair to say that the court's comfortable with that concept, and it will generally find a conflict, if there is one, between what the requirements that underlie state tort action and the federal statute or regulatory provision. Now, the court has confronted this in pretty much all manner of different contexts, and we're going to talk specifically about sort of the pharmaceutical context here. But to be clear, this is a recurring issue that happens in virtually every substantive area where there is both federal law and state law. And if you just take a look at the latest Supreme Court decision in one of these areas and try to extrapolate from that decision what's going to happen next, you will be profoundly frustrated. Because even though the constitutional principles that emanate from the Supremacy Clause are relatively straightforward, their application in a particular context really is a very detailed exercise in statutory construction, regulatory interpretation, such that how the court decides one preemption case doesn't really tell you much about the next one. And people, tend to get overly excited one way or another when they read, the latest Supreme Court decision. And maybe the best illustration of this is the so-called presumption against preemption. Now, if you're a student of the court's preemption cases, you will start to notice that the presumption against preemption appears in virtually every Supreme Court case that finds there not to be preemption. So in finding the state tort law not preempted, the court will talk a lot about this presumption against preemption. Of course, when the court finds state tort law preempted, that same presumption tends to be just absent. It's not that the court carefully analyzes and finds it overcome. It's just that whoever's writing the majority opinion in that case tends not to dwell on it much. It might show up in the dissent, for example, but otherwise it won't. Now, you could sort of, as I say, dismiss that as just sort of hypocrisy or, kind of a convenient relationship. There's something similar going on when it comes to the Lemon test and Establishment Clause cases. But I think it's more than that, which is I think what it shows you is that ultimately the reason that these cases are being decided the way they are decided is, again, not some overarching principle or presumption that really carries through from one context to another, but it is this idea that, based on the justice's analysis of the particular regulatory and statutory environment, they either think that it makes sense to have a uniform federal rule that displaces state law, or they think it does not. And I think when you're arguing these cases in the Supreme Court, I think you sort of rely on broader principles to your detriment. And I think, these cases are won or lost in the sort of details of the regime. And it's hard to find a better illustration of that than just a quick walkthrough of the court's cases, starting with its medical device decision in Regal, then its decision in the context of branded pharmaceuticals and failure to warn claims in Wyeth, and then its two more recent cases involving generic drugs. So starting with Regal, Regal was a case involving an injury that arose out of the use of a Class 3 medical device that had gone through the pre-market clearance process before the FDA. And in the Regal case, the court found that a design defect claim based on that medical device was in fact preempted by the federal regulatory regime, and that in a sense the court's reasoning was that by going through the pre-clearance process, that had in fact imposed requirements for the device that preempted conflicting requirements for the device that might be imposed by state tort law. Now, when Regal came out, it was greeted as a very big deal because not only had the court found preemption, but it had decided it by a relatively lopsided margin, 8-1. Even Justice Stevens joined the decision of the majority, finding the state tort law preempted. So it came as a fairly significant surprise just a couple of years later when the court decided the Wyeth case in the seemingly relatively similar context of pharmaceuticals that have also branded pharmaceuticals that have also gone through a fairly elaborate clearance process in the FDA, that the court found by a 6-3 margin that a failure to warn claim was not preempted in the context of a branded pharmaceutical. Now, I think the specific reasoning of the court here focused on something that I think others will talk about, which is the FDA's CBE, or changes being affected regulation. And the gist of the majority opinion was that it was within the capacity of a branded pharmaceutical company to get its label changed, even though it's not easy and even though it's not something they could do, like as a matter of whim unilaterally. There was a process at the FDA where they could change their label. And as long as there was that process, then the court did not perceive a significant conflict between the federal requirements to label a drug in a certain way that FDA approves and the state tort law, which would have effectively required the manufacturer to change the label. Now, the two quick observations about Wyeth. One is, you can't help, all of these cases are hard. And they're hard for the defendants to win, in part because you typically have a very badly injured and very sympathetic plaintiff. But it was really hard to beat the plaintiff in Wyeth against Levine, and I do think the facts of that case probably had some influence on the court. And I'm sure those of you that are more expert in FDA law than me will take issue with this, but when you have somebody that's taking a pharmaceutical for something that doesn't seem like the world's biggest problem, nausea, and they end up with gangrene, that's a bad dynamic to try to suggest that there's no remedy under state law or really any other law. So I think that's part of what was happening there in that case. The second thing, though, as I say, although the decision was 6-3, the single most consequential opinion going forward is actually not the majority opinion, but is the concurring opinion by Justice Thomas. Because Justice Thomas had traditionally been, although not an entirely reliable vote for defendants, at least an available vote for defendants in implied preemption cases. And Justice Thomas rather boldly in this decision announced that he was effectively getting off the implied preemption train. And at one level it seems surprising because some of the most sort of ardent proponents of finding preemption have typically been justices like Justice Scalia, Justice Alito, who you might think of as his fellow travelers. On the other hand, there is a certain sort of logic to it because Justice Thomas doesn't like implied causes of action, doesn't like implied rights, really doesn't like implied anything. So from that standpoint, it's actually quite consistent for him to not like implied conflict preemption principles. But then I think his sort of abhorrence of implied conflict preemption, I think, ends up helping to explain the two other decisions that I'll mention just very quickly. So we find out in medical devices we have preemption, branded pharmaceuticals we don't. So surely generic pharmaceuticals are more similar to branded pharmaceuticals than they are to medical devices, right? No. So the court in two generic pharmaceutical cases finds that there is, in fact, preemption of both failure to warn and design defect claims. The first of those cases, the Plivon, might not be saying that right, against Menzing case, and there the court decides 5-4 in favor of preemption in a decision written by nobody other than, of course, Justice Thomas. And Justice Thomas this time finds preemption, but not because he's back on the implied conflict preemption train, but he finds this time what's called impossibility preemption. And he says it's just flat out impossible for the generic pharmaceutical manufacturer to change the label, at least unilaterally. And so there's some discussion in the various opinions. Well, the generic pharmaceutical manufacturer could talk to the FDA and could initiate a process saying the label is insufficient. But since the label is effectively the property of the branded manufacturer and not the generic manufacturer, the justices by a 5-4 margin say there's preemption, impossibility preemption. And then they follow that up a couple of years later in the Mutual Pharmacy against Bartlett case, again a 5-4 decision, this time written by Justice Alito, and find that the same logic applies to design defect cases. And the last thing I'll say about these cases before turning them over is I think you see two things here. One, you do see, because of Justice Thomas's unique position, this really shift in focus from implied conflict preemption to impossibility preemption. But then secondly, that really begs or prompts the difficult question of, so what does it mean for something to be impossible? What is possible? And what do you mean by that? Because surely it is possible for a generic pharmaceutical manufacturer, even under the existing law, to precipitate a process that could lead to the change of the label. Surely it's possible for a generic pharmaceutical manufacturer to simply not market their product in a particular state that requires a different design for the product. And that was the principal argument in the Bartlett case about why impossibility preemption didn't apply. And so these various notions about sort of what counts as possible and impossible, and then also what is it that the state is really requiring. Because in all these cases, the court was quite deft in saying, well, the duty on the manufacturer, for example, in the Menzin case, was not a duty to go to FDA and get the label changed or to try to go to FDA and get the label changed. The duty was to not market the product with that label. And because the generic pharmaceutical manufacturer couldn't directly change the label itself unilaterally, the court said that was enough for impossibility preemption. So all these are, I think, very interesting and, difficult questions. I think that there's obviously an effort underway to change the regulations in a way that might affect the ability of generic manufacturers to take advantage of these preemption holdings. And all of this, I think, has really, as I say, Justice Thomas, I think, has single-handedly shifted a lot of the emphasis into the realm of impossibility preemption. But that's kind of it for my opening remarks. So thank you.
Our next speaker is Gerald Masoudi, who is chairman of Covington's Food and Drug Practice. Gerald went to the Cook County College of Law, where he also was the editor of the law review there. Until 2009, he had various jobs at the FDA, including last job as Chief Counsel, and then he joined Covington. Gerald, you're on.
Great, thank you, and thanks for having me. I'm sorry I can't be there in person. I thought now that we've had that good introduction by Paul, I would dig a little bit more into the regulations and some of the regulatory history, including some of the things that went on within the agency with regard to preemption, just to give you a little more flavor for how we've really ended up where we are. Preemption was one of the issues that I was looking at pretty carefully when I was Chief Counsel, along with some of the First Amendment issues that have arisen and that I know Paul's dealt with and others have dealt with. And where we are on preemption really is the result of a couple different but related sets of rules on labeling. So first, there are the rules about changes to labeling. FDA approves drugs with particular labeling that must accompany the drug. And that is set as of the time of approval, but of course there's always new information. There are manufacturing changes, potentially new warnings, other information, new studies that should go into labeling, and so FDA has a set of rules that govern when labeling can be changed. There are three essential ways to change labeling. One is through what's called an annual report, where you just go ahead and make the change and tell FDA about it later. Those are rare and very minor changes that can be made that way. Most labeling changes are done through a pre-approval supplement, under which a drug sponsor needs to get FDA's approval before it distributes the new labeling. And then there's a narrow category of labeling changes called changes being effected, where the company can make the change immediately unless FDA later disapproves it, in which case the company has to go back to using the old labeling. Now, for purposes of preemption, the CBE route is important because the CBE rule covers changes to add or strengthen a warning. And so those are the kinds of changes that are generally at issue in tort lawsuits. And plaintiffs will say, well, you always could have used the CBE regulation to change your labeling to add or strengthen a warning. The second set of rules are the rules on adequate directions for use. And there's a misbranding provision that says that all drugs must have adequate directions for use, and FDA can create exceptions to that requirement. FDA found some time ago that prescription drugs, as a matter of law, cannot have adequate directions for use, and therefore they must rely on an exception in order to be lawful. And the exception that FDA created was to say that your drug must have directions for use, including warnings, dosage, etc., and the document that you use to convey that information must be the FDA-approved package insert. In addition, in order to qualify for this exception, any promotional labeling has to be consistent with the package insert. So this set of rules on adequate directions for use essentially extended FDA's control over labeling from the package insert, over which it has complete authority, and extended that to promotional labeling, which is a significant expansion. And all of this is to say FDA really likes to have complete control over the labeling, but at the same time, it doesn't want to be blamed in the event that warnings don't get added to prescription drug package inserts. It doesn't want to be in a position where a sponsor asks to change the labeling and FDA is blamed for any delay. And hence the CBE regulation creates this ability under some circumstances for drug companies to add or strengthen warnings. Now this can be logistically difficult because if a sponsor adds warnings through the CBE rule, it can start distributing the drug immediately with the new package insert. But then if FDA later disapproves the CBE, the sponsor has to then revert to the old package insert, and this creates all sorts of logistical problems. So this is the set of rules that we were operating against when I came into FDA, and some of the principles we were acting upon, and I think most people will agree with these, are that warnings in drug labeling should be meaningful, that overwarning is a problem, and if there's overwarning, then that will prevent meaningful warnings, important warnings, from getting to patients. And that sometimes FDA does reject warnings. When it believes that a warning is unfounded, that it's incorrect, FDA will reject, under some circumstances, will reject warnings and tell sponsors not to provide the warnings in their labeling. So the real problem that existed as of the time when I was at FDA was that the CBE rule on its face said that you can add or strengthen a warning and didn't really give any qualification to adding or strengthen a warning, and said, you can go ahead and add warnings, which of course, if people really took this to its logical conclusion, this could be disastrous. It could result, if people really added all sorts of warnings and made, added up every potential warning on their labeling, that would be a real problem. And in fact, FDA did not operate in the way that the rule on its face might suggest. FDA did not take the position that you could always add whatever warning you wanted. There has to be evidence, and it's got to be new evidence. You can't, the day after your drug is approved, add a warning that FDA rejected in your package insert. That's not the way things work. So in 2008, the agency put out a revision to the CBE rule to make the rule match the ordinary practice, which was to say you can make a CBE change to add or strengthen a warning based on new information, and you can do it only when there's sufficient evidence under the labeling rules to support a warning, which means it has to be a warning that's a real issue and that's substantiated. Now, of course, in the Wyeth case, that did not make a difference, and I think part of the reason is that the court, based on the facts, could and did say, even if it requires new information, even if this warning could have been added only with new information, there was new information in this case, and I think that might be part of the difference between how the Wyeth case came out and how the Mensing case came out. But that's then where we were, and then as Paul pointed out later, when the court decided the issue in the context of generics, said there actually is preemption because it's not possible. So then continuing on the regulatory history, FDA has now put out a proposed rule saying Well, it's an additional background fact in the CBE ruling before is that FDA said a CBE supplement to add a warning without pre-approval cannot be done by generics, and that's of course what was underlying the court's decision. And so FDA has now put out a rule that says, well, actually generics can do this. We are going to allow generics to change their labeling to add or strengthen warnings, and we'll create an intricate system where we'll put proposed warnings up on a website, and we'll work it out so that everybody's labeling eventually will be the same. But for some time, there may be differences in the labeling between the innovator drug and the generics. Now, this presents a real problem, because in a multi-source environment where you have an innovator product and you have generics that have been found by FDA to be bioequivalent and really ought to have the same warnings, you now have a situation that could cause tremendous confusion in the marketplace as you have different drugs which are supposed to be the same having different labeling. And so that's now out by FDA as a proposal. And the situation really is problematic, because in the world where you don't have preemption for innovators, but you do have it for generics, you have a situation where some courts might be inclined, which I think doesn't make a lot of sense, but some courts might be inclined and have found that innovators should be responsible for harms to patients who took generic drugs. And I think that's a sharply minority position, and that's not the way the law should or will go necessarily, but there is the specter of that out there. And that, of course, could cause all sorts of problems in terms of hampering innovation by innovators, and also encouraging innovators, once there's generic competition, to merely withdraw their new drug applications, which could cause its own problems, given that the innovators generally have the most information about the drug. So that's just some of the regulatory history about where we are. I mean, I think my view is that a better direction for FDA to go, rather than having multiple different package inserts for really what's found by FDA to be bioequivalent drugs, would be a pre-approval system. Go back to a pre-approval system where there are accelerated applications on safety issues, that everyone has the ability to go to FDA and provide new information. But really, in order to ensure that there's no confusion in the marketplace with different drugs with the same drug essentially having different labeling, that's really the direction they ought to go. I'm not saying that's where I think they will go, but that's just one direction that I think might be beneficial. So just with those thoughts, I'll then hand it over to our next panelist.
And our next panelist is Andrew Boczkowski, who is an Assistant General Counsel at GlaxoSmithKline. He's a graduate of Villanova Law School. He then clerked for Judge Bechtel in the Eastern District of Pennsylvania, then private practice at Stradley and Ronan in Philadelphia, and in 2004 went to Glaxo.
Thanks, everybody. Hello. I'm here to give a little perspective on what the in-house counsel at a pharmaceutical company looks like when a product liability case comes in the door now. And we have either preemption issues at play or the effects of preemption issues in play when there's innovator liability allegations against a branded pharma. The first thing that we do is we don't just throw preemption aside anymore, because the Wyeth v. Levine case, while it dashed a lot of hopes for preemption for all, did contain some language in it that said if there's clear evidence that the FDA wouldn't have approved an alleged warning, that you still might have a case for preemption. So our search for the facts of each case really revolves around looking for this, what I call like the elusive exception to the Wyeth-Levine case. The SSRI category of litigation has a decent chance here. There were some wins on this issue before Wyeth v. Levine. There are some facts in these cases where the FDA looked at a ton of data. Public citizen petitions were rejected by the FDA. And there's still hope out there, I believe, for a Wyeth-Levine versus exception in fact patterns that are similar to that. So that's the first thing we do. The other thing that's good about doing the preemption analysis is to really dig into the regulatory history of a case. Even if you won't win summary judgment, you're going to come up with a lot of facts that help adequacy of warning arguments before a jury. So the second sort of thing we'll look at here is the risk of innovator liability claims, and this is primarily for branded pharma. We sort of feel left out. Regal's pretty good for a medical device, and the generics have a pretty good deal with Mensing, and we kind of feel left out. But what's even worse about that is the effect of the Wyeth, Levine, and Bartlett Mensing together really means plaintiffs are searching for a theory where we can be, the branded pharmaceuticals can be liable for a drug even if the person never took our branded pharmaceutical. And that's based on our duty to maintain the language of the label presumably forever. So the trick there is that I don't think any of the laws that were at play in Pleva or Bartlett really ever contemplated that branded pharmaceuticals would be the insurer for an entire industry forever. And then the other thing is that state product liability law has traditionally said you've got to take the drug to have product liability at all. And we're not going to make a distinction about whether there's a fraud or misrepresentation allegation. So that's changing, and the main thing that we're worried about now isn't whether they're going to win a preemption argument, but whether we're going to have thousands and thousands of lawsuits for drugs that weren't ours. The third thing that we keep an eye out for is hope for a better future, and things like what's being proposed by the FDA may provide an answer. So if there's parity where all of pharmaceutical can make a CBE label change together and we're all on the same playing field, that makes branded pharma feel a little better, because then the risk of expansion of this innovator liability theory goes down, but we're still left in an area where there's not really much preemption defense left because we're stuck with Wyeth Levine. But if Jerry's hope comes true, where there's a pre-approval system for all, we'd kind of be cutting the underpinnings of the Wyeth Levine decision, and preemption would be back on the table. And then all of Paul's knowledge about the justices would come back into play, and we can predict again. But that's basically the thought process when a case comes in the door at our company.
Paul or Jerry, before I open it up to questions, does anyone want to comment on what any other speaker stated?
Well, I mean, I'll just make a couple of quick comments. One on each. I think Jerry would kind of already intimated that he wasn't necessarily predicting what the FDA was likely to do, just what would be sort of a good idea from a policy standpoint with respect to the idea that the FDA could go to a more rigorous sort of pre-approval system. But I think in an earlier comment, I think Jerry really kind of laid the foundation for why the FDA as a practical matter is not going to do that, which is simply they don't want to own the label. Jerry worked at the FDA. The FDA was just my client, so maybe I'm a little freer to take a whack at them. But they are an organization that, for perfectly understandable reasons, if you sort of believe in kind of political choice theory and all of that kind of stuff, they really want to sort of assert a lot of regulatory control without any definitive ownership. And you see this in a variety of concepts. Where it really, kind of bothers me from a jurisprudential sort of and also good government standpoint is the off-label context, where, it would be perfectly rational to have a system where there's no such thing as off-label use. Every use has to be approved by the FDA. But of course, you'd have to have a radically different FDA that actually didn't have a huge backlog and was actually responsive and actually could consider the fact that the medicine moves and that the standard of care for a lot of conditions is an off-label use. I mean, you just can't have that world. But the FDA is perfectly happy with this, I think, objectively ridiculous situation where, you have approved drugs for one use and, doctors are free to promote off-label use. It can become the standard of care. But if somebody inside one of the companies says anything suggesting that might actually be a good thing, then the U.S. Attorney's Office is going to come knocking. I mean, if you take a step back, there's no rational justification for that system. It's horrible. But it's a reflection of this idea that the FDA likes to regulate without really owning it. And I think you have the same thing with the label. I mean, they don't really want people changing the label without their approval, as Jerry suggested, and as he suggested when he was reminiscing about when he used to wear the FDA hat. But by the same token, they're not, I don't think, ever going to go to a system where they really completely own the label in a definitive way, because I don't think, I don't think they have the current capacity to really handle that responsibility, which I guess is the most charitable thing I could say in their defense. But again, I just think it's a very difficult situation to defend as a public policy matter. And then the only other thing I will mention in terms of the innovator issue is, this whole idea seems crazy. And, it would be, I think, really sort of, kind of attractive to just say, oh, come on, this can't happen. I mean, you can't actually be liable for a product that you didn't sell anyone. That can't be right. But I will say, having, been involved in a number of lawsuits over the years where things like, causation got thrown out the window, and other things that you just understood as being bedrock principles of state tort law, I think it is, you're absolutely right to be concerned about this. And although it's always been a bedrock principle of state tort law that you're not liable for somebody else's product, that stay tuned, because I don't think, there's enough movement in the law and in fairness, enough, concern about the anomaly of somebody who's, badly injured but can't get compensated because they took the generic version rather than the branded version. All of that creates pressure on the system. And I'm not so sure that the state tort law is, so firmly planted that it can resist that pressure. And I guess, the last thing I'll say is one of the things that does make all of these issues difficult is that, it'd be a lot easier to win the preemption argument if there were some alternative means of compensation. And another case that I was involved in actually for GSK, among others, was a Supreme Court case, the Brushewitz case involving preemption in the vaccine context. And, the vaccine providers prevailed in that case, but in some respects, although it was closely fought and the court was divided, it's a much easier context because you're not saying, nothing as the alternative. You have something behind door number 2, and it's a rational compensation system that makes it relatively easy to get compensation. Certainly a lot easier to defend these cases if you had something like that on the table as well.
Sure. Jerry, in case you didn't hear it, it's basically what are the courts doing with the clear evidence standard to meet sort of a Wyeth-Levine exception? I mean, there haven't been that many cases, to my knowledge, that interpreted this. I believe something got up to the 10th Circuit in an SSRI case 2 years ago. I think there was a good district court opinion. It was up on appeal. I forget which company had it, and it settled. I think Merck has something in its Fosamax case that's up before the 3rd Circuit now. Oh, so they got an actual rejection. So I don't think the law's really been developed, and my guess is that it would come out in SSRI litigation because it's still bumping around all over the place, and I feel like at some point one of those cases is going to percolate up. Before Wyeth was decided, our company had a case called Colachico in the Third Circuit that we won on that issue. And the fact pattern, I think, would hold up, but it hasn't been tested there yet.
Right, and I think if I could just add, I think one of the difficulties in those cases is, the way the FDA process works is you ask for a specific warning, and FDA might modify that warning or it might reject it. But enterprising plaintiffs, I suspect, will say, well, you asked for this warning, but maybe you should have asked for something a little bit different. And if you'd asked for something a little bit different, then maybe FDA wouldn't have rejected it. So I suspect that'll be part of these cases as well.
Yeah, and then the other thing that the plaintiff's bar will say is, well, there is new information. You've collected 75 more AEs in 3 years, and this study had an outlier finding or something like that. So that one bothers me a little bit because there has been some other, I think there's a Supreme Court case in the sort of the securities law space that kind of said for just a really little bit of data, it could be one AE, could really change the outlook there. Now, hopefully that won't get extended and applied, but we'll have to see.
And Gerald, the question was, in Massachusetts, the state banned a medicine that had been approved, and the district court found that that was preempted. And the question is, what is the panel's view on all of that?
Well, I'm not overly familiar with the decision, but that's never stopped me. So I'll give you a couple of thoughts, which is, I think that takes you back to kind of the origins of preemption. And I think it's worth kind of, especially, for folks that, are in-house or are very used to sort of invoking preemption defenses. I mean, they're an important part of the law, but this whole notion of preemption defenses in state tort cases is a relatively new phenomenon. And, the real kind of heartland of preemption is something much more like this case, where you have a state regulatory action. And, it seems pretty obvious to me that, you can't have individual states basically taking drugs off of their market independent of the FDA. That does seem quite contrary to the thrust of the FDA's, jurisdiction and the Food and Drug Act and the like. But I don't. So I think to the extent states try to do stuff like that, you will find a preemption result. I think, though, that it will be hard to extrapolate from that, because you could extrapolate from that as saying, well, all these state tort, cases are really very similar, because at one level or another, they're sort of saying that you have to take the product off of the market, at least in its current form, even though it's been approved in that form by the agency, by the FDA. And I think in the tort context, it's much easier for the courts to have some skepticism, because they're dealing with a plaintiff who, in most of the cases, appears to be manifesting some very serious injuries that often are demonstrably linked to the product. So they are actually injured, unlike some other plaintiffs that recover. So it puts them in a tough position, and I think because it's involved sort of an application in a snapshot in time where the person was injured, it becomes easier to say, well, maybe the FDA approved it, but we don't know that the FDA would have had the same information at the same time. But it's in the nature of these kind of conflicting regulatory determinations that they're roughly contemporaneous. I mean, the FDA right now says that product should be on the market. Massachusetts right now says it shouldn't be on the market. And so I think the combination of those two things just makes those much easier cases for courts to say, no, that's preempted, you can't do that.
And Paul, that segues into a question that I had. If we're in the district court or a circuit court, we're not in the Supreme Court, and we have a truly neutral judge. She just wants to get to the right result. And the issue is preemption on a device or a medicine. And I always call them medicines, not drugs. I think we all should do that. But we have that issue. Should we be citing to the other preemption jurisprudence, seatbelts in the area of product liability, or preemption on financial products, or the District of Massachusetts case that apparently is out there, or citing in the district court and the circuit court only to the pharma device Supreme Court cases?
Well, I'll take a crack at it, which is I think it depends a little bit on the case and depends on sort of who you are. I mean, if you're a branded pharmaceutical company, I'd sure want to broaden the lens beyond Wyeth, because it's not a particularly helpful lens. If I were a generic company, I'm not sure I'd cite anything but Mensing and Bartlett all day long. And if I were a medical device manufacturer, I'd rely on Regal and assume that was going to get me home. So I think the sort of scope for creativity in citing things beyond sort of Wyeth is probably with the branded companies, and I think it makes sense to try to kind of argue about sort of some of these broader principles or borrow. I mean, you mentioned the SEC case, which I think is like probably the Matrix case you're thinking
Matrix,
of.
that's it,
Right.
yeah.
But so that's not one you'd want to borrow because that's unhelpful. But there's some stuff out there that's better, and I think you could certainly try to build that up and broaden the analysis. I do think as a practical matter, I mean, you talked about this platonic judge who's really struggling to get the right answer. And there certainly are, plenty of very, very good judges out there. I think as a practical matter, though, it's just worth recognizing that it's a big ask to tell any judge that, they ought to be the one that finds, the clear rejection or whatever the exception language in Wyeth is. The first court of appeals judge that's going to do that is going to know that they will be accused of thumbing their nose at the Supreme Court in the Wyeth decision, and they're going to know that there's going to be, a credible cert petition filed in the wake of that case. And it certainly suggests that A, from the defendant perspective, you hope it's a good case with a strong record where it's really sustainable. And B, I just think as a matter of kind of, watching the human behavior of those humans that are judges, that's a big ask to ask them to do that, because I think the path of least resistance for everybody is to not get much beyond the four corners of the Wyeth decision in a branded pharmaceutical case. And, I think it will be kind of easier for a judge to just sort of read the atmospherics of that as not being great for the defendants, as opposed to, parse the language and find the way through. That's not to suggest you shouldn't, try very hard to get the courts to focus that and to build the best case. But I think it's just, to be realistic, that's a fairly big ask.
And Gerald, would you recommend in the district court or circuit court in the brief, and I'm going to use the verb, dumping a lot of the regulatory stuff in, or would you recommend being bigger picture on that?
I think it depends on the facts, but I think in most cases I would dig into the regulations to where you can establish what it is you could and couldn't do. So I would err on the side of doing that, but I suppose it might differ from case to case.
Any other questions for us? Why don't I just turn it back just for a minute to each of the panelists, and this is kind of an unfair question, but tell us where you think we're going in preemption in the next year or two. And Gerald, I'm going to turn to you because you may have addressed it already, but I'm talking not in terms of the FDA, but in terms of the courts.
Well, I think a lot of it depends on what FDA does. So even though you said you're not looking for that, I mean, I think FDA may very well try to finalize this rule that allows generics to make changes, in which case I think the courts will, this will then reopen the question of whether generics get preemption in the first instance. And then we may end up in a situation where nobody gets it except in unusual circumstances.
Andrew?
Yeah, that's where I come out. I think some court will interpret what this clear evidence means under Wyeth sometime in the next 2 years, and then whatever the FDA does, I think I agree with Paul that the FDA not really wanting to own the label means that the most likely thing is that the proposed rule actually gets passed, and then we have arguments where the generics will challenge the legality of passing such a a rule, whether there's authority to do that at all. If that gets upheld, then you're just going to have a situation where Wyeth-Levine kind of applies to everybody, and that's where it'll lie. But the innovator liability expansion may die because of that.
Yeah, I think that's largely right. I mean, I would only add that I think in the context of the FDA, if the FDA goes forward and sort of finalizes the rule, there's really sort of two kinds of challenges that the generic companies can bring. I mean, one kind of challenge really goes to the question of whether the FDA has the authority to do what they're purporting to do. And without trying to handicap the strengths or weaknesses of the argument, there's certainly a credible argument that says that, the statutory framework for generics is so based on the idea that, their equivalence of the product then translates to an equivalence in the label and the like, that the FDA can't do what it's purporting to do here as a matter of kind of statutory interpretation. And I think it depends a little bit on the details of what they do, but there may be specific arguments about, can you really have, again, consistent with the statute, these competing labels out there for what is, by statutory requirement, the same darn thing. And I think there's at least an argument that you can't. And that's really an ad law challenge that presumably would be brought to the rule. I also think, though, that even if that fails, there is an argument to be made that what the FDA is purporting to do is not a sufficient sort of fix, with that phrase in quotes, to actually strip the generic companies of their preemption defense. And that really, I think, turns on the details of exactly what the regulations ultimately look like, but also a little bit some of these ideas of what do you mean by kind of possible, impossible, if it's structured in a way that the generic essentially owns their own label to the extent that they can make a unilateral change. That will make it harder to make any argument that there's preemption left. But if there's any kind of intervening role for the FDA to play in the process, then that is certainly some language in the Mensing case that suggests that if you can't do it kind of sort of unilaterally and independently, then there's still the possibility of raising a preemption defense based on impossibility. And of course, there is also the possibility, I suppose, that by the time that issue, which would really be litigated more in the context of an individual tort claim, and so that's an issue that's probably 4 or 5 years away from getting to the Supreme Court. There is a possibility that the composition of the court could change one way or another. I mean, it could mean that, frankly, the sort of defendant's case is dead on arrival because you now have a majority of justices that think that Mensing and Bartlett were wrong. So who cares whether, this fits within those decisions if they're wrong? Or you could conversely, have, say, a fifth justice up there who actually believes in implied conflict preemption, and, the dynamic could change. So, stay tuned to be sure. I think there's that issue. It will have a fairly long gestation period, and by the time it gets back to the court, it'll be pretty hard to predict. Well, and Jerry, I'll summarize the question this way, which is, why are we talking about failure to warn claims when nobody ever reads these labels anyways? And stated that way, it's certainly a fair question. I do think that, ultimately, there's a little bit of a fiction, but it's a fiction that goes to the jury. And, the jury ultimately makes a determination that a different label would have made a material difference. I mean, to me, and now I'm probably, skating well beyond the topic, that we're here to discuss. But, the question also to me brings to mind this idea that, for some of these drugs and for some of the conditions, I mean, you are dealing with something that, is not that radically different from the situation you're dealing with in the vaccine context. Vaccines are different because you start totally healthy, and you're asked to put something into your body that's foreign, even though you're totally healthy. And that's why you get people who resist vaccines. That's why it made sense to Congress to create an alternative sort of compensation scheme. But with at least some, medicines, if you have a similar dynamic, which, okay, well, I'm sick, and there's like a really, really good chance this is going to help me, but there is some non-trivial chance that it's not going to help me. I'm not even sure that the warnings are really that responsive to that situation at all. Because presumably if I'm warned at the time, I say, I don't know, what does my doctor think? And at that point, my doctor says, I wouldn't have prescribed it if I didn't think it was the right thing to do, and then you take it. And the warnings don't have much to do with it. Now, if I'm nonetheless injured because there was a 0.0001% chance that I'd get some horrible thing, and if you told me that I was going to get that, I'd be like, well, I don't want it. Then, there is this impulse to compensate. And, I do wonder, if, in some ways, again, if you were sort of czar of the legal system, as they used to talk about at the Cambridge Community College, if you were czar of the legal system, I don't know that you would, create a system where you put all this pressure on these doctrines of preemption. But you might say, well, what's rational here is to basically put the FDA in charge of this bus. And then when people are unavoidably injured, you provide a compensation scheme for them. But it's a rational compensation scheme. It's not a lottery ticket that might get you punitive damages or at least might get your lawyer rich. It's much more like you have in the vaccine realm. I mean, something like that, if you really want to think sort of down the road about what might, allow the government and the courts ultimately to move to a more rational system. I mean, I think something like that, merits a lot of consideration.
Just to follow up on your question a little bit, when we lose preemption, we don't lose the case. So sometimes the adequacy of warning goes to things like, is there a state law where there's a presumption or punitive damages are limited? And then even if you lose on those, it's still the heart of the case. All the facts that we develop, that's why we dig into the regulatory file for each drug. It's all about adequacy.
Yeah, and I do think in most cases, I mean, obviously you can have some cases where there's some, side effect or something that nobody saw for a while, and all of a sudden they see it, and it really changes the dynamic. And I think, part of the reaction I think at least some of the justices had in the Wyeth case was, given the other things that are out there to treat nausea, why would anybody run the risk of this? Really, I think it was a case that just on a common sense level, maybe inaccurately, I don't know anything about the drug or how it works or how bad the conditions it treats are, but I think just at a common sense level, I think some of the justices were thinking that was a case where if you were warned, you wouldn't take it. But I do think, again, I don't know this, but my impression is there are lots of other ones where where the dynamic is much more like the vaccine context, where there is a known side effect, there is some unavoidable risk of it in certain patients, and if you warn somebody about that, I mean, all they're going to do is ask their doctor and then take it if their doctor says it. And, just, saying it twice or underlining something, I don't think is really going to change the human behavior very much. And, so I certainly understand the impulse behind the question. And I do think that in that respect, the Wyeth case, whether it was or not, may have appeared to be to the justices to be a little bit of an outlier in terms of being a fact pattern where the nature of the condition, the nature of the side effects, they might have thought, that's one where what can happen? I can lose an arm, would have made a difference.
What's strange about that is, well, the ultimate patients maybe don't read the labels very much. The assumption under the law is that the doctors read them very, very carefully and know everything about them, and then go read all the studies and do bonus research on it. And that may not be the case with every drug.
Right, and what's additionally interesting is that with regard to the package insert, as I mentioned, under the adequate directions for use, FDA has found that it's not possible to write a package insert for lay use, and that really they're written for the physicians because they can't be written in a way that consumers would understand them fully.
But let me ask a question of my more learned colleagues. But in practice, isn't it the case that in a lot of these situations, yeah, okay, there's the label, but ultimately there's a determination made kind of less at an individual doctor level, but sort of as to what's the standard of care for a condition. And that at a certain point you just get to the idea that for a certain condition, a certain drug is the standard of care, notwithstanding the fact that it has some side effects, and a slight change of the label is not really going to impact the doctor's prescribing decision. Is that wrong?
Right.
Or?
I think in general that's right. And unless you've got a drug that has a new black box warning added to it or some major change, I think that a lot of physicians don't may not pay attention to all the changes that are going on.
Yeah, I mean, I think you got it right, Paul. I mean, it really is that's litigation is born out of the change from everything was fine to now there's a black box, and now everything should have been not fine 10 years ago. This debate, in some respects, is about who owns responsibility for the safety data. The branded pharmas do all of the studies, they a lot of clinical trial work. The generics maybe have bioavailability, but then once the branded sort of loses that exclusivity, a shift begins. On day one, our great market share goes down significantly, and all of the data that's being collected falls away from us. Then it's not coming into our company anymore. It's coming to our competitors. And what's to be done when the shift of new data actually starts moving to other companies? What role do they play in safety, and what responsibility do they have for updating labels? I think that's where the argument lies, and that's why all these debates are happening.
No, I mean, I think that if that's the price that comes along with being an innovator, once there's generic competition, people will just withdraw their NDAs, and they'll say, forget it. We're, even though we've got the best information about this, we can't continue to be responsible for what other people are doing.
I do think there is this profound impulse in state tort law that says you are liable for your product, and that's because you always have the option of taking your product off of the market. And the implications, I think it's fair to say the implications of the argument that you're making are that you sort of lose that at some point. That because you've unleashed this, and because you took the sort of innovator profits that went with unleashing it, you now own it at some level until it's taken off the market by others. And wow, I mean, it would be an innovation, but but to be clear, I don't doubt the ability of Eric to persuade some state court judge or somebody else to persuade a state court judge that that's the right answer. And again, just to underscore the point, and I think that's because you do have this, there's lots of law professors at various community colleges, in Cook County and in Cambridge, will talk about the idea that when you have a real asymmetry in the law, it puts pressure on the law. And we do have this asymmetry in the treatment of branded and generic pharmaceuticals, and it creates a pressure that I think will find itself, at least in some courtrooms, kind of resolving itself by accepting this argument in circumstances where otherwise they might not be inclined to accept it.
No, and I mean the one way it could really play out is that the law is these cases just remain the same, and innovator liability doesn't become a trend. I mean, we've got one state Supreme Court that's adopted it, no one else. There's the Conti opinion in California and a couple other district courts. Maybe it might just stay like this for a while. That's probably one logical conclusion.